Hello. In this video, I will be discussing 3 great immigration options that are available for startup companies. If you are planning to establish a startup in the United States and are curious about potential immigration options for which you may be eligible, then you've come to the right place. I'll be covering what you need to know, so be sure to stay tuned. The first option we will discuss is the E-2 Treaty Investor Visa. This visa allows employees and entrepreneurs/investors from treaty countries to live and work in the U.S. With approved E-2 status, an individual can reside in the United States and manage their business by making a significant investment in their enterprise. This option is particularly ideal for startup companies. Let's now discuss the requirements for the E-2 visa in detail. First, you must possess the citizenship of a country that has an E-2 treaty with the U.S. Although numerous countries have E-2 treaties with the U.S., some notable countries like India and South Africa do not. To check whether your country of citizenship is E-2 eligible, go to travel.state.gov and look for E-2 treaty countries. Be sure to check in with an immigration attorney if you are thinking about acquiring citizenship in a third-party country for purposes of E-2 visa investment, as legislation introduced in December of 2022 attempted to limit non-E-2 treaty citizens from acquiring citizenship of E-2 treaty countries for purposes of U.S. investment. Second, you must make a substantial investment in your business. There is no fixed dollar amount considered as substantial, but investments of at least $100,000 are recommended by our law firm. However, investments for less than this amount can also qualify and lead to approval. The formula immigration uses to weigh whether an investment is substantial takes into consideration the proportionality of the investment to the total cost of the business. Third, you must have the intent to leave the U.S. once your E-2 status ends. If you have applied for a green card in the past or are currently in the green card process, be sure to raise this issue with your attorney. Fourth, your business must be an active, for-profit enterprise. Simply investing in the stock market is insufficient to qualify for an E-2 visa. Your startup must be an active entity, such as a restaurant, franchise, cell phone repair shop, or other business. Fifth, your business cannot be a marginal enterprise, which means that it can't be so small as to solely benefit you and only provide enough income for you and your family. In other words, the enterprise must have the potential of generating a significant income beyond that which is needed for the investor and his or her family. Sixth, you must come to the U.S. to direct and develop your business, and your investment funds must originate from a lawful source. In other words, you can't use funds obtained through money laundering or any other illegal activity to fund your enterprise. Last, your funds must be at risk. This implies that you can't simply deposit money into your business bank account and anticipate your E-2 visa to be approved. You must put those investment funds at risk, for example, by purchasing equipment, supplies, and making necessary purchases for your business. Let's now move on to the second option in today's presentation, which is the L-1 visa, also known as the L-1 Intercompany Transferee Visa. The L-1 visa allows a foreign company to transfer a manager, executive, or specialized knowledge worker to work for a related U.S. company. Think of well-known companies with offices all over the world that move employees around: General Motors, McDonald's, etc. The L-1, however, is not just beneficial to these huge corporations. Through the L-1 visa, a foreign company, even a small one, can transfer certain employees to work for a related U.S. company, including the establishment of a new office in the U.S. The L-1 is a great option for startup companies in the U.S. because it allows a foreign company to transfer a foreign worker to establish a new office, even if it's a brand new business. Now let's discuss the requirements for the L-1 visa. The first requirement is that there must be a qualifying relationship between the foreign company and the U.S. company. This means that the U.S. company can be a branch office of the foreign company, a parent/subsidiary of one another, or the companies can be affiliates of one another, but there must be some sort of a qualifying relationship. The second requirement is that the employee who is coming to work in the U.S. must have been continuously employed by the foreign company full-time for at least 1 year within the last 3 years prior to filing the L-1 petition. This means that the employment with the foreign employer must have been full-time, continuous, and lasted for at least 1 year full-time within the last 3 years prior to filing the L-1 petition. The third requirement is that the employment with the foreign company must have been as a manager, executive, or specialized knowledge worker. This means that the role with the foreign employer must have been as a manager, executive, or specialized knowledge worker, and not any other role. The fourth requirement is that the prospective employment with the U.S. company must also be as either a manager, executive, or specialized knowledge worker. In summary, the L-1 visa allows a foreign company to transfer certain workers to work for a related U.S. company. Let's now move on to the third and final immigration option of today's presentation, which is the International Entrepreneur Parole Program, or IEP. This program allows the Department of Homeland Security to use its parole authority on a case-by-case basis to grant a period of authorized stay to foreign entrepreneurs who demonstrate that their status in the U.S. would provide a significant public benefit. The program enables an entrepreneur who satisfies the requirements to come to the U.S. and be eligible to work for their startup business, making it a great option for startup companies. To qualify for IEP, an immigrant entrepreneur must meet several requirements. The first requirement is that the entrepreneur must have substantial ownership of the startup entity, at least 10%. The second requirement is that the entrepreneur must have a central and active role in the operations of the startup entity. The third requirement is that the startup must be a U.S. business entity that is lawfully conducting business in the United States and must have been formed within the 5 years immediately preceding the application for initial parole. The fourth requirement is that the startup entity must have the substantial potential for rapid growth and job creation. In conclusion, the International Entrepreneur Parole (IEP) program is a valuable option for startup companies looking to establish themselves in the U.S. as long as they satisfy the requirements outlined by the program. To summarize, we discussed 3 immigration options for individuals who want to operate a startup company in the United States. The first option is the E-2 investor visa, which permits an individual to invest in a U.S.-based business or franchise and manage it through investment. The second option is the L-1 visa, which allows a foreign company to transfer a manager, executive, or specialized worker to work for their U.S.-based company, which can also be a new office. The last option we discussed was the International Entrepreneur Parole (IEP) program, which offers startup founders and entrepreneurs the opportunity to come to the U.S. and stay for a specific period to develop their businesses. Thank you for watching our video. Don't forget to like this video and subscribe to our channel to stay up to date with all of our videos. See you next time.